So what happens if you make a homeless application and the council tell you that you don't have a local connection? In one sense it can be challenged, but in order to challenge it you obviously need to know what local connection means and essentially what difference it makes, because it's probably the biggest myth out there about housing law that you need a local connection to make a homeless application. And to make sense of this video, I just need to briefly outline what local connection is, what the criteria is, and before we even get there I need to say that there are two definitions of local connection. One applies to you if you make a homeless application, and one applies to you if you're not homeless and you apply to the council's housing register. Now there's obviously some crossover there, but the law says if you approach either of those processes and in doing so you give the council reasons to believe that you might be homeless or you might be threatened with homelessness, they should immediately deal with it as a homeless application. The fancy word for that is Part 7 rather than Part 6. So we're just talking about Part 7 in this video. A bit of jargon there. I've done other videos about that, expanding on it. And very briefly, the definition of local connection under Part 7 is that you need to have lived in settled accommodation in the district for either 6 out of the last 12 months or 3 out of the last 5 years, or 3 out of the last 5 years, have close family in the area who've lived there for at least 5 years, or have a permanent employment contract in the area, which would actually include volunteering. If you're interested about that, check out Fox v Ealing. I did a video about that as well. And there are some special circumstances as well, because the mathematicians out there will realise that actually many people will have more than one local connection even before you get any further, because you might have lived in one area, you might have family in another area. But at the early stage of making a homeless application, it doesn't matter, because the most important section of the Housing Act 1996, in my opinion, is Section 184. That is the duty for councils to accept applications and start the inquiry process. And you'll notice it's basically dependent on asking a council for help with housing and giving them reasons to believe that you might be homeless or you might be threatened with homelessness. Local connection does not matter, intentional homelessness does not matter. It's just about satisfying those two criteria: asking for help with housing, giving them reasons to believe that you might be homeless or you might be threatened with homelessness. You'll also notice that the next duty that really matters is Section 188, which is the interim accommodation duty, or probably more widely known as the emergency accommodation duty, which is the duty to provide emergency accommodation if there is reason to believe that you might be homeless, might be eligible, and might have a priority need. And again, you'll notice it does not mention local connection or intentional homelessness for that matter actually. And even then you can go further, because the next thing the council has to do is work out, are you actually homeless, and then are you actually eligible for assistance? And if the answers to those questions are yes, then they have to carry out an assessment under Section 189A and create a personalised housing plan with you. This is all before local connection becomes relevant. This is probably where it's good to differentiate between the prevention duty, which is owed to you if you're threatened with homelessness, and the relief duty, which is owed if you actually are homeless already. And the prevention duty does not take local connection into account at all. So you can go through all the way through the prevention duty, and the council could identify that you don't have a local connection. They might contact the council where you do have local connection to see if they'll cooperate in preventing your homelessness, but probably that doesn't happen very often. So within the prevention duty, local connection does not matter. Local connection does not matter until the point where the relief duty starts, and that is where a council will look to refer you back to an area where you do have local connection if it is safe to do so. But there's a little bit more to say about that. Now, immediately you'll notice that where you've got situations you're fleeing domestic abuse, this mechanism allows you to approach any council in the country. They have to accept the application, they have to offer interim accommodation if there is reason to believe that you might be homeless, might be eligible, might have a priority need. And then even if they try to refer you back to your home area, they can't, because the other authority can reject that referral if there is any risk to you in that district. That does not mean you can also approach a district where there is a risk. That's another story. But in real terms, if you've made an application and you're actually homeless already, and therefore the relief duty is about to kick in, that is when the council will use the formal referral mechanism to refer you back to an area where you have local connection. Now, because it's possible to have multiple local connections, you can essentially choose which one they refer you back to. There's no good reason for them to disregard your wishes there. And essentially they'd fill in some paperwork, send it off to the other council, and a few days later the other council would accept it, and the other council would then continue. So I guess it's important to understand that although you can approach any council in the country, in most instances where it is safe for you to be in your home area, it makes sense to approach a local authority where you do have a local connection. And in cases where you've got multiple local connections, you can approach one or other, or one of a number of councils in order to progress that application. But it's important to say as well that councils do not have to do that at all. There's no duty on them to refer you to a different council. It's just a power. They can do it if they want to, but they don't have to. And because councils are so strapped for cash, in the real world they are often going to refer you whenever they can. But that is very different from literally just telling you, oh, you can't make an application here, you have to go to an area where you've got a local connection. As I say, that's unlawful. The whole way the law's designed is to catch people and stop them falling through the net, because there are other situations where it would not be safe to refer someone back to an area. And the point is that the council is essentially supposed to accept your application and figure out with you what the options are, rather than just saying, oh, off you go. Because there are many cases where people get sent back to an area where they're at risk. You might have heard me talk about a case, one of the first cases I dealt with, where Shepway District Council, rather than accepting an application from a homeless woman at risk of domestic abuse in Bedford, they simply just said, oh, here's a bus ticket back to Bedford. There was no application accepted. There was no assessment really of the risk, even though the victim did say that she was a victim of domestic abuse. And so the law is designed to avoid that sort of thing happening. Interestingly, it was a charity which paid that bus ticket. So if you're a charity, you work with local authorities, it's probably a good question to ask, whose side are you on? Because that sort of action should never happen. That kind of collusion with unlawful activity shouldn't really ever happen if you're a charity who are out to protect the rights of your clients. There is another thing that can happen here, because councils not only can refer you just before the relief duty starts, they can actually also refer you when they have accepted the main duty, which I think is just an artifact from before the Homelessness Reduction Act kicked in. So before the HRA kicked in 2018, councils were not able to refer people back to their home area until they'd made a final decision on that application. Because it doesn't exist anymore, it's probably not worth going into much detail about that. But essentially that's what happens if you don't have a local connection. You can approach anywhere. They have to take the application. They have to offer interim accommodation if you are owed that duty. They have to carry out an assessment. They have to engage with a prevention duty with a PHP if you are threatened with homelessness. But if you're actually homeless, they can refer you back at that point. But there's a number of other things that's probably worth bearing in mind. So for example, you might have a local connection to an area through family connections. You might have a brother or a sister living somewhere, but you hate their guts and you don't want to be anywhere near them, and so you approach a local authority. They cannot refer you back to that area where you've got family if you don't positively want to live there. If you want to find out more about that, check out 10.9 of the Code of Guidance, which is the rule book for councils. You can just Google it. There's also things around people who are sleeping rough, because obviously the definition of local connection under Part 7, under the homeless application process, it requires that you live somewhere in settled accommodation for either 6 out of the last 12 months or 3 out of the last 5 years to get the connection. But obviously if you're rough sleeping or sofa surfing, that just isn't possible. So the Code of Guidance does also say that in effect, in that situation, if you actually reside in a district, you have a local connection to it. And that might be proved, I guess, through things like accessing local services, accessing GP, accessing a pharmacy, something like that. But in theory, I guess the Code of Guidance says that unless the council know that you have settled accommodation elsewhere, it's probably not going to kick in. I remember hearing about it in Southampton, for example, where they were just adamantly refusing to help someone because they thought he had a local connection elsewhere. But the law says they had to accept the application, properly assess his situation, and then work out whether they should in fact refer him back to that area or not. So that's something to bear in mind. And also you're going to get situations where people come through the asylum seeker route or something like that, where they don't have any family connections, they haven't lived in settled accommodation, and so there's a slightly different test there as well. And it's probably just worth finishing by just emphasising this difference between the Part 7 definition, the homeless application definition, and the housing register definition. I'm still yet to find a way to explain this very well, but effectively the homeless application definition is always the same. It's always those 6 out of the last 12 months or 3 out of the last 5 years, whereas the housing register application definition will always be different, or almost always be different, depending on which council you go to. And what happens a lot is that someone approaches a council and they incorrectly apply the Part 6 definition, which is almost always more strict. I think there's only 2 councils I know of where it's actually more relaxed than the Part 7 definition. And so people get told, you haven't lived here for 3 years, you need to go somewhere else. That is the wrong approach from the council. That's unlawful. That's going to leave people who might well be at risk of harm in harm's way. So if you want to challenge that, essentially what you need to do is you need to make sure that you've actually made a homeless application, because many staff don't get any training on this anyway. They don't even understand very basic things about this. Let's take Hillingdon, for example, not because I've worked with Hillingdon, but because they've got the most strict residence criteria, which is 10 years. Someone could approach Hillingdon Council. They might have lived there for 6 out of the last 12 months in settled accommodation, so they would have local connection under the Part 7 definition. They make a homeless application, or they try to make a homeless application, but a housing officer helpfully tells them that because they haven't lived there for 10 years, they can't apply. That is completely incorrect. In one sense, you've got these 2 definitions, and if you're homeless, you go through the easier route when it comes to local connection. It's not easier in other ways. And that effectively trumps the Part 6 definition, because what happens is, if you're owed either the prevention or the relief duty, or even the main duty for that matter, you get what's called reasonable preference, which is essentially a duty that means that you have to be put onto the housing register. Now, it might be at a very low banding, admittedly, but it is still on the housing register. And that means that when you think about it, if you can approach any council in the country, let's say you're threatened with homelessness, they have to take the application, they have to carry out an assessment, they have to create a personalised housing plan, and they have to engage with the prevention duty. Whilst you're under that prevention duty, you should be getting reasonable preference on their housing register. That will seldom result in anything good, because in most cases getting that low banding is not going to get you somewhere in that time limit, but it can happen. I have seen it happen. I have seen people with the lowest banding get accommodation. It tends to be the hard to let properties, which are not very nice properties, but obviously still better than nothing. And I guess if you're going to, if that is your plan, you need to find a local authority with very short waiting list, or the shortest waiting list you can find. You might have seen the video I did about how long does it take to get housed. That would be an indicator, although in that case I'm actually measuring a slightly different statistic rather than the kind of the lowest banding. So hopefully that all helps. Summary is, you can make an application to any area, but pragmatically speaking, unless you're fleeing from an area, it makes sense to go to an area where you do have a local connection, because ultimately what's probably going to happen is you will get referred back somewhere at the end of that process. But I guess technically speaking, it is possible that you would get some assistance, because under the prevention duty, for example, they would probably tell you if you can find a landlord, a private landlord in the area, they will help you with that upfront cost. And that's plausible. I'm not saying that every council would do that, but that would plausibly happen if you literally waved the landlord in their face and said, yeah, this landlord will take me, can I have the money to kind of cover the first month's rent and the deposit? They might say yes. That is, who's to know. But in most councils, obviously, where there is that kind of ridiculous strain on resources, I'm not sure that's going to be the best approach. But anyway, I hope that helps. I hope it kind of gives you an idea of how local connection does work and how it doesn't work. Just how that there is always some kind of assessment and advice and assistance that you should get if you approach a council when you're homeless, irrespective of local connection. So yeah, anyway, if you've got any questions about it, put it in the comments. As always, I'll take them to the weekly live stream if they're a bit more involved. If they're just kind of very snappy, I'll just respond back immediately if I can. And I guess as well, if you find this stuff useful and you want to get involved in a bit more detail, you want to help other people get housed, I do some training kind of along these lines, online training every month or so. Do an open course. It's 30 quid if you're coming on your own back and paying for it yourself, £60 if you're coming from your employer. People end the day just really buzzing about it. And I guess it's just that foundation. You need to start pulling all these different strands together to start helping people getting housed. So yeah, do consider that. Check out the Eventbrite link in the description if you're interested. If not, hopefully see you on a live stream at some point.